Hello, welcome back to episode 2 of the Eviction Series. This episode is going to be about you getting evicted because the landlord or their family is moving in. So a lot of people have sent in that has happened to them. I want to talk about what the requirements are under the Act and kind of things that landlords do that aren't really allowed. What you can do about it. Section 91 ZZA of the Residential Tenancies Act 1997, Victoria, covers this whole situation. So this is obviously going to be very specific to Victoria, and it's not really going to give you any legal advice. I'm just going to talk about the law that covers this situation. So 91 ZZA refers to the residential provider giving you notice to vacate your rental because they're moving in. So the key pieces of this section are that pretty much the landlord, either the landlord themselves or their partner, child, parent, or partner's parent, or someone who's kind of financially dependent on the residential provider, they're going to move in immediately after your rent, your fixed lease ends. So this can't be served to you before the end of your fixed lease, your fixed period, and they do have to give you 60 days notice. So if they haven't given you 60 days notice on the notice to vacate, that's not allowed. So ignore that. Don't actually ignore that. There's probably something that's wrong. So yeah, pretty much I've been hearing that a lot of people are getting notices to vacate because their landlord is moving in, or the landlord's partner, or kind of close relative of their landlord. And there's been a lot of stories of they get an eviction notice, the renter gets an eviction notice, and then the landlord doesn't actually move in. They start doing a bunch of renovations and don't move in. Generally, that's illegal, and I'll talk about why. But pretty much step 1 is covered by section 91 ZZO of the Residential Tenancies Act, and it says that it has to be in the required form, the prescribed form. The prescribed form is in the other video that I've done, episode 1. It's pretty legit. It has the Consumer Affairs Victoria kind of heading, and it has to include all the things in there. If it doesn't, something dodgy is probably going on. But if it does, it also needs to include documentary evidence. So section 91 ZZO requires that if you're giving a notice to vacate under section 91 ZZA, which is the rental provider moving in, it has to be accompanied by documentary evidence as approved by the director from time to time. So this is the documentary evidence required by the director. So you can find this in the Victorian Government Gazette number S142, Thursday 25 March 2021. It's the same as the other one, but it pretty much says that, hey, if you're evicting someone because the landlord wants to move in, you need to provide a witnessed statutory declaration signed by the rental provider stating either they intend to reside in the rented premises, or the name of the person who's going to be in the rented premises, and also that you acknowledge that you understand you can't re-let the premises to any person other than the person that is already going to be moving in for use primarily as residents before the end of 6 months. So if you get evicted and less than 6 months later, someone other that, like, you see it advertised for rent on Domain or realestate.com.au, that's not allowed, and that's actually that is an offence under the Act, and there's a bunch of things that they can do. They can get a big old fine, blah 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 blah. So if that happens, definitely contact Consumer Affairs and let them know, because that isn't allowed unless they have already got a VCAT order, which they usually don't. Let's go a bit more into detail about section 91 ZZA. So recently, section 91 ZZA replaced section 258 of the Residential Tenancies Act, the old one. Fortunately, there's not much wording that was changed. It's pretty much exactly the same section, which means a lot of the old case law still applies. So it's a very recent kind of new act, so there's not much new case law, but we can use the old case law to kind of see what's happening. The act states that the premises are immediately going to be occupied after the termination date, and there is a case that kind of discusses what is meant by immediately, and the case is, what is the case actually? The case is whatever this person is and whatever this person is, but it's in paragraph 67. It's its ordinary meaning being without delay. So if the landlord doesn't actually move in for like 3 months, that's not immediate, that's not allowed. There are some exceptions, however. So in this case, which was from 2020, the tribunal member did say that, hey, the landlord was going to do some carpeting and painting, which took around 4 to 6 weeks, and that's fine. That's not kind of like any major renovations or anything. That's like, hey, I want to install the NBN before I move in, or do some carpet, do some painting, whatever. That's fine. This tribunal member still considered that immediate, even though it's between 4 to 6 weeks, which is not what I'd consider immediate, but hey, I'm not a Vacate tribunal member. And yeah, now I really want to talk about kind of the most common thing that happens, which is the landlord doesn't actually move in, and there's kind of some evidence that they're not going to do that. So this is Rizio and XEP 2020, and pretty much the VCAT found that, hey, the landlord had a proven history of kind of wanting to redevelop the premises. There was planning permits that existed for demolition, and they already had kind of other houses that they could move into. So the notice to vacate wasn't really legit. And this is how you can, if you suspect that your landlord isn't actually going to move in to your property, because they're going to develop it and then just rent it out later, or are going to do a bunch of other stuff, this is how you can check it. So if you go to planningalerts.org.au and you just type in your address, I don't know, I'm going to use 300 Sydney Road, boom, Coburg, go search, sort by closest. So this will show you if there's any kind of development applications for that particular address. If there's a development application and it's a pretty big one, like a demolition, or like they're going to subdivide, or they're going to install a new shed or something, that's pretty clear evidence that the landlord doesn't immediately intend to move into that property. So you can challenge that notice to vacate quite successfully, because you can be like, hey, there's a planning application, the landlord's not going to move in immediately. Something else you can do is you can call your local council and ask, hey, what's going on? I've just got a notice to vacate. However, I suspect that maybe they're going to do some development. Can you confirm whether there's a development application or not? And if there is, you can challenge that notice to vacate. Unfortunately, a lot of this has to happen kind of after the fact. So say you got evicted because the landlord was moving in. It's 3 months later, you see no one's there, no one's living there, and there's a lot of tradies and there's a bunch of kind of development happening, but no one's actually living in the premises that you got evicted for because someone was going to immediately occupy that place. It's actually, so they have to provide, to evict you properly, they have to provide a stat deck, and the stat deck has to say, hey, this is going to be my primary place of residence. If they've given you a stat deck in your notice to vacate, which they are required to do, and they're not actually occupying the premises, that is a criminal offence. So it's a criminal offence to lie in a stat deck, and that can achieve 5 years imprisonment, or I think it's 160 penalty unit fine. But yeah, so if that happens, it's like 3 months later, no one's moved in, and you've got your stat deck saying, hey, I'm the landlord, I'm going to move in, call the police. Just call the police and be like, hey, I've got someone who lied on a stat deck. they're probably not going to do anything, but it is pretty scary if you're a landlord and you kind of hear the police going like, hey, did you lie in this stat deck? They're going to probably have to try fix that situation. Yeah, this one's pretty simple. Ultimately, in summary, in order to evict you under Section 91 ZZA, they have to give you your notice to vacate in the prescribed form. So if it doesn't look like that, something's up. So challenge that immediately. In that prescribed form, they also have to give you a signed stat deck that says, hey, this person's going to move in. And those really are the only requirements under the Act. It can't be before the end of your fixed term lease. So that's also something to note. And they have to serve it to you properly. They can't just leave it in your letterbox or leave it on your front doorstep or whatever, unless they can leave it in your letterbox if it's sent by registered post. But that's also something to consider. Yeah, if they haven't done any of those things, or it's quite clear that they're not going to move in, it's really important to either speak to Consumer Affairs, speak to Tenants Vic, or speak to your local community legal centre who deals with kind of tenancies. If you don't know who that is, feel free to message me and I can find you your closest community legal centre. But also, if this has happened to you, please reach out to me, let me know. Let's go fuck that landlord up, because that's illegal and a crime as well. But yeah, if you've got an eviction notice recently, please send it through, or like leave a comment saying which section of the Act you were evicted under, and I'll do a video on it, on what to look out for and what you can do. And also, if you have any additional questions about this specific topic, or this has happened to you and there's something else that I didn't cover, again, leave a comment, let me know, and we can go into that. I can do another video or whatever. Also, you can post on the Shit Rentals subreddit, so definitely do that. If you find like a really fucked rental or rental listing or something, anything to do with renting, really. It's not limited to Victoria. You can be from anywhere, doesn't matter. Also, check how cool this shirt is. It's a bonsai thing, except it says all landlords are bastards. So if you want to buy that, you can buy it through the link in my link tree, but you definitely don't have to. So thanks for listening, love you, and I hope you don't get evicted. Fuck.